Today we discuss navigating California trade secret protection in a post-non-compete landscape. The legal landscape for protecting trade secrets has gone seismic shifts in recent years, driven by evolving restrictions on non-compete agreements and heightened emphasis on employee mobility. With California leading the charge in banning non-competes and the proposed nationwide prohibition, businesses must rethink their strategies to safeguard sensitive information. We explore the interplay between non-compete agreements and trade secret protection and offer actionable insight for startups adapting to this new reality. So, in 2024, California enacted SB 699 and AB 1076, laws that void non-compete agreements for nearly all employees, even if signed outside the state. Key provisions include non-competes are unenforceable against employees working in California regardless of where it was signed. Violators face fines and lawsuits for damages, attorney's fee, and injunctive relief. And employers must inform current and former employees that the non-competes are. So these laws favor California's long-standing policy favoring worker mobility, forcing companies to rely on alternative tools like trade secret law and confidentiality agreements. So, why non-competes matter for trade secrets? Non-competes historically acted as a buffer against trade secret theft by delaying employees' ability to join competitors. Without them, businesses face two critical challenges. Employees can immediately transition to rivals, increasing opportunities for inadvertent or unintentional disclosure of confidential information. Trade secret litigation requires demonstrating reasonable efforts to protect secrecy, a higher burden without non-competes. So what can founders and companies do to protect their trade secret? To mitigate risk, companies should adopt a multi-layered approach. First, prohibit employees from disclosing trade secrets during and after employment. Use clear definition of what is confidential information, such as, let's say, algorithms, your methods for training the AI, or customer list, for example. You should restrict poaching of clients or employees, provided they're tailored to avoid functioning as the de facto compete. And you should ensure that IP developed by employees belongs to the company. And as far as onboarding and offboarding protocols, you should train employees on handling trade secrets and company policies and require a signed acknowledgement of confidentiality obligations. You should also, during an exit interview, remind departing employees of ongoing confidentiality duties and recover company devices and revoke access to the digital systems that the departing employees have access to. You should also consider technological and physical safeguards. You limit access to trade secrets to employees with a need-to-know basis. You use tools to track data movement and prevent unauthorized transfers, and lock physical documents and restrict access to facility to only need to know. You need to encourage a culture of confidentiality, and Apple is great at this. You should educate your employees on identifying trade secrets and reporting breaches, and encourage executives to model and enforce confidentiality standards. So, California's experience offers a blueprint for operating with non-competes. The California Uniform Trade Secret Act, or CUTSA, allows injunctions and damages for misappropriation even without non-competes. Courts enforce NDAs and non-solicitation agreements if they're specific and avoid overbreadth. Companies like Apple use trade secrets for hard-to-patent innovations such as manufacturing processes or AI training methodology. So, patent is always a part of the IP tools, but we need to consider the patent versus trade secret crossroad. With non-competes in decline, businesses must reevaluate their IP strategies. Let's compare patent versus trade secrets. The disclosure factor in a patent is that it's going to be public. A trade secret is obviously a secret. The duration of a patent is 20 years, whereas a trade secret is indefinite if you maintain your secrecy. The enforcement cost of a patent is high, whereas a trade secret enforcement would require proof of misappropriation. Patents, therefore, are best for things that are easily reverse engineered, such as things that a customer could buy and then open up and see how it works. Trade secret would be ideal for processes, formulas, negative R&D research. A famous trade secret is the Coke formula. Pharmaceutical companies also use trade secrets for manufacturing techniques while they patent the drug formulation because that is easily reversible. You also want to consider global issues. So while the US non-compete laws evolve, international employers must navigate various regimes. Non-competes are enforceable if limited in duration and scope, but in some countries, such as Germany, they require compensation for a restricted period. Jurisdictions like Japan and Singapore allow non-competes but demand geographic and temporal reasonableness. There is an act called Defend Trade Secret Acts, or DTSA, that can provide extraterritorial reach if the misconduct originates in the US, offering a lifeline for multinationals. So in conclusion, in building a resilient trade secret program, you should consider the following. The decline of non-competes demands a paradigm shift in IP protection. By combining robust contracts, technological safeguards, employee education, and strategic use of patents, businesses can thrive in this new era. California's experience proves that trade secrets remain viable, but only with proactive, cross-functional effort. If you have any questions, feel free to visit patentpc.com. We're happy to answer your questions.